I have met many people with a disability that requested help for their vocational rehabilitation services, Department of Rehabilitation. They were unable to attain needed services or did not even know what services they could request. This has resulted in many not being able to attain meaningful employment, keep employment, or graduate college. Many feel hopeless and as if they have no future. I hope this video and my other videos help. The other videos that might help are free money for college, start a business, people with disabilities and learning disability. Federal law allows you to discharge your student loans after 25 years without filing bankruptcy. Bankruptcy, collection agency, wage garnishment, student loans, Social Security. We put links to all of the laws mentioned, with links to our YouTube channel and our website in the description below. All you have to do is expand the description and you will see all of the links. Impartial due process hearing, administrative review. The information in the videos applies to vocational rehabilitation services, Department of Rehabilitation. Every program such as food stamps, Section 8 housing, or unemployment insurance operates under different laws. The law stated in this video will not apply to food stamps, Section 8 housing, or unemployment. However, the procedures and the process can apply to food stamps, Section 8 housing, or unemployment insurance. Whenever you have a problem with the state government for issues relating to food stamps, Section 8 housing, or vocational rehabilitation services, you can request an impartial due process hearing. This means that you are appealing their decision. If you lose in an impartial due process hearing, then you can request an administrative review. In some states, the administrative review is conducted in court. However, some states are kind of fair, where other states have passed laws designed to ensure you lose. Example 1. What the government said is considered true and cannot be questioned. In most states, whatever the government said is considered true and cannot be questioned unless the statement is completely ridiculous. You had 3 business consultants review your business plan, with a combined experience of 60 years, and they all said independently that it is a good plan and should be funded. Your counselor said he does not think it is a good plan. Yet, your counselor has no real business expertise. Unless you present the fact that your counselor has no real business expertise and your 3 business consultants have a combined experience of 60 years, you will lose. Your counselor represents the state, and what the state says is considered true, and it cannot be questioned unless it is ridiculous. The state could have their own business consultant that said your plan is not good. Unless you can prove that your 3 business consultants are reputable, you lose. The only way to win in these states is to say that the government did not follow the law. Example 2. The government did not follow the law. If you prove the government did not follow the law, you might still lose because the legal procedure might say that you cannot present the law at an impartial due process hearing. This is because questions concerning the law are beyond the authority of the impartial due process hearing judge and have to be presented in court. Therefore, the law might also say that the impartial due process hearing judge can only consider state policy. Thus, if state policy violates the law, the impartial due process hearing judge cannot consider it, which will guarantee that you will lose. The law might also say that if you did not present it at the impartial due process hearing, you cannot present it at an administrative review or in court. This means that you cannot present federal laws at the impartial due process hearing, which will guarantee that you will lose at the impartial due process hearing, administrative review, and lose in court. The only way to have a chance at winning is to verbally state the federal law, the complete federal law, or as much as you can, and then let the impartial due process hearing judge tell you over and over that they cannot consider it. This way, you will be able to present the federal laws in an administrative review or in court. The most important thing I can tell you is the following. 1. Verbally state the federal laws at the impartial due process hearing. If it is not verbally said, the court might not be able to consider it. In some states, the court can only consider what is in the transcript. Even if you have it written down, in writing, and request the impartial due process hearing judge reviews what you have written, unless it is verbally stated, the court might still not be able to consider it. 2. If you have to go to court, do not go to state court. Go to federal court. State court is more of a political body, where everyone has contributed to everyone's campaign. People get appointments to become judges or head of different agencies because of who they know. Article 6 of the U.S. Constitution states that federal law always overrides state law, but state court judges have come up with creative reasoning not to follow the U.S. Constitution. Federal court judges always follow federal laws. Impartial due process hearing for vocational rehabilitation services or Department of Rehabilitation. When the Rehabilitation Act was written, they knew about all of the state laws that would ensure you will lose and attempted to write into the Rehabilitation Act clauses to prevent this. The following should work in every state, but it does not mean that you will win. When vocational rehabilitation services or the Department of Rehabilitation deny you any service, you can file an appeal, which means requesting an impartial due process hearing. You do this by filling out a form. The following is what you put on the form, and tailor it to your situation.
I'm requesting accommodations for my disability. My medical record or my psychological assessment states that my disability encompasses issues relating to speech, hearing, problem-solving skills, processing speed, memory, short-term or long-term, reading, writing, concentration, focus, all of which affect my ability to communicate. Therefore, I need the hearing judge or officer to read and understand everything attached to this form, including the following federal laws and federal regulations. Federal Laws 29 U.S. Code Section 722, and 29 U.S. Code Section 723. Federal Regulations 34 CFR 361.5, 34 CFR 361.48, 34 CFR 361.45, 34 CFR 361.50, 34 CFR 361.52, 34 CFR 361.54, and 34 CFR 361.57.
You might not use all of these laws, but this gives you a better chance if you have to go to court. This method might provide the court with the ability to consider all the federal laws. Plus, the laws you do not use here you might have to use in court. Next, state the services you have been denied. This part is very important because one of the excuses vocational rehabilitation services or the Department of Rehabilitation have used is to say that the services you are requesting are not vocational rehabilitation services. Because of this, federal laws do not apply. Remember, some of the services stated in 34 CFR Section 361.48. Scope of vocational rehabilitation services for individuals with disabilities should be in conjunction with 34 CFR Section 361.5. Applicable definitions.
I have been denied the following vocational rehabilitation services, which are the services I am requesting. 29 U.S. Code Section 723. Vocational rehabilitation services. A 12. Occupational licenses, tools, equipment, and initial stocks and supplies. A 13. Technical assistance and other consultation services to conduct market analyses, develop business plans, and otherwise provide resources, to the extent such resources are authorized to be provided through the statewide workforce development system, to eligible individuals who are pursuing self-employment or telecommuting or establishing a small business operation as an employment outcome. 34 CFR Section 361.48. Scope of vocational rehabilitation services for individuals with disabilities. 5. In accordance with the definition in Section 361.5c, 39, physical and mental restoration services, to the extent that financial support is not readily available from a source other than the designated state unit, such as through health insurance or a comparable service or benefit as defined in Section 361.5c, 10. B8. Transportation in connection with the provision of any vocational rehabilitation service and in accordance with the definition of that term in Section 361.5c, 57. B16. Occupational licenses, tools, equipment, initial stocks, and supplies. B19. Technical assistance and other consultation services to conduct market analyses, develop business plans, and otherwise provide resources, to the extent those resources are authorized to be provided through the statewide workforce development system, to eligible individuals who are pursuing self-employment or telecommuting or establishing a small business operation as an employment outcome. 34 CFR Section 361.5. Applicable definitions. C57I, Examples. The following are examples of expenses that would meet the definition of transportation. The examples are purely illustrative, do not address all possible circumstances, and are not intended as substitutes for individual counselor judgment. Example 2. The purchase and repair of vehicles, including vans, but not the modification of these vehicles, as modification would be considered a rehabilitation technology service. 34 CFR Section 361.5. Applicable definitions. C39. Physical and mental restoration services means I. Corrective surgery or therapeutic treatment that is likely, within a reasonable period of time, to correct or modify substantially a stable or slowly progressive physical or mental impairment that constitutes a substantial impediment to employment. 2. Diagnosis of and treatment for mental or emotional disorders by qualified personnel in accordance with state licensure laws. 3. Dentistry. 15. Special services for the treatment of individuals with end-stage renal disease, including transplantation, dialysis, artificial kidneys, and supplies, and 16. Other medical or medically related rehabilitation services.
Next, you want to try to ensure that the hearing judge or officer only considers the state policy that is congruent with federal laws. Therefore, state the following.
According to 34 CFR Section 361.57. Review of determinations made by designated state unit personnel, an impartial hearing officer cannot consider any state policy or state law that are not consistent with federal requirements. 34 CFR Section 361.57. E3. The impartial hearing officer must I. Make a decision based on the provisions of the approved vocational rehabilitation services portion of the Unified or Combined State Plan, the Act, federal vocational rehabilitation regulations, and state regulations and policies that are consistent with federal requirements.
All of what has been stated will help ensure that if you have to go to court, you will be able to present all of the federal laws. Plus, if the court finds that the hearing judge or officer did not follow 34 CFR Section 361.57, E3, then that ruling can be dismissed or thrown out. Next, state the following.
To ensure that the court will review my case under federal law, I am presenting the following. 29 U.S. Code Section 722, C, states the following, which says it directly. It cannot be misinterpreted. It is not ambiguous or unclear. 29 U.S. Code Section 722, C1, states, each state shall establish procedures for review through an impartial due process hearing of determinations made by personnel of the designated state unit. 29 U.S. Code Section 722, C2AI, states, the eligible individual has the right to obtain review of determinations described in paragraph 1 in an impartial due process hearing under paragraph 5. 29 U.S. Code Section 722, C5a, states, a due process hearing described in paragraph 2 shall be conducted by an impartial hearing officer. 29 U.S. Code Section 722, C5i, states, if a party brings a civil action under subparagraph J, to challenge a final decision of a hearing officer under subparagraph A, the final decision involved shall be implemented pending review by the court. Thus, 29 U.S. Code Section 722, C5J, is a court's review of an agency's decision. 29 U.S. Code Section 722, C5JI, states, any party aggrieved by a final decision described in subparagraph I may bring a civil action for review of such decision. The action may be brought in any state court of competent jurisdiction or in a district court of the United States of competent jurisdiction without regard to the amount in controversy. 2. Procedure in any action brought under this subparagraph, the court, I, shall receive the records relating to the hearing under subparagraph A and the records relating to the state review under subparagraphs D through F, if applicable. 2. Shall hear additional evidence at the request of a party to the action, and 3. Basing the decision of the court on the preponderance of the evidence, shall grant such relief as the court determines to be appropriate. Federal Regulation 34 CFR 361.57 states, the designated state unit must ensure that an eligible individual who is dissatisfied with any determination made by the designated state unit may request a timely review of that determination. The procedures must be in accordance with paragraphs B through K of this section. I comes before K. Thus, 34 CFR 361.57I is a court review of an agency's decision. Federal Regulation 34 CFR 361.57I Civil Action. 2. In any action brought under paragraph I of this section, the court I receives the records related to the impartial due process hearing and the records related to the administrative review process, if applicable. 2. Hears additional evidence at the request of a party, and 3. Basing its decision on the preponderance of the evidence, grants the relief that the court determines to be appropriate.
A trick you can do, res judicata and the Rooker-Feldman doctrine. Legal doctrine is not law but has the same effect as if it is the law. One can say that it is the legal policy that all courts follow. The Rooker-Feldman doctrine means that if you start in federal court, you cannot switch to state court, or if you start in state court, you cannot switch to federal court. Res judicata is double jeopardy but for civil court cases. It means that once the judge makes a ruling, you cannot bring the issue back to court. Trick number 1. However, the Rehabilitation Act provides a way around both. If you lose, you might be able to bring your case back to court or change from state court to federal court. First, you have to request Vocational Rehabilitation Services or the Department of Rehabilitation to close your case. Then wait 1 to 6 months and reapply for services. It is very important that they do not reopen your case. You want a new case with a new case number. When you go to court, make sure the court knows, in writing and verbally, that your case was closed, you had to reapply, and now you have a new case with Vocational Rehabilitation Services or the Department of Rehabilitation. This should get you around both res judicata and the Rooker-Feldman doctrine. Trick number 2. Another trick you can do is ask for new services. Go through the list of services in 34 CFR section 361.48 and see what else you might need or want. Since these are new services, this means that this is a new issue. Therefore, res judicata and the Rooker-Feldman doctrine does not apply. However, you still will not be able to bring up any old issues. Combining trick number 1 with number 2 will give you the best chance. Conclusion. Remember, try and verbally state as much as you can at the impartial due process hearing. If you have to go to court, file your complaint in federal court and not state court. Some federal courts have forms that you can fill out and instructions regarding the process. None of this means that you will win, but it will give you a fighting chance. Good luck. Best of luck.
Please hit subscribe or like. Thank you.